Items and visitors, public comment time. The Joint Plan Commission and Zoning Board of Appeals allows 15 minutes for non-agenda items to be addressed by any individual who wishes to approach the commission. We would ask if anybody does want to address a non-agenda item that they limit their comments to 3 minutes. Anyone in the audience who wishes to participate in a non-agenda item? Seeing none, we'll go to agenda item number 4. For those who want to give testimony tonight, we'll have to give you an oath. So please stand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? Thank you. Please be seated. Agenda item number 5 tonight. Public hearing for text amendments establishing the recreational, institutional, and open space known as Rio zoning district. If Mr. Cole would like to give an overview, that would be great.
Certainly. And I'd note as well, Mr. Chairman, I think our intent is to have one hearing, a consecutive hearing, for both the text amendment piece of this and the map amendment piece, so putting properties into the district. It's a little bit of a technical clarification, but one to make sure we were on the same page. So I've got a short presentation. We'll try to leave the balance of time for comments, certainly. What are we doing tonight? So tonight, again, we have 2 items before us on the PCZBA's agenda. One is a text amendment, amending the text of the zoning regulations to create a new district, to create a whole new set of regulations applicable to that district, to make some other tweaks and changes along the way necessary, just to make that fit within our existing framework of uses and how we control development in the village. We also have a map amendment. So now that we've created the district, we're talking about rezoning over 200 different parcels in the village into this new zoning district. Probably, we're talking about it today, as far as we know, this is probably the biggest rezoning in the village in a long time, maybe ever. So just in terms of the sheer number and mass of area affected. What we're talking about tonight is really making a zoning district for what we've called the Rio uses, for a Duran Duran fan. This is taken from our use table that we're proposing, but churches, libraries, public agencies like the village, like the park district's offices, museums, recreational spaces like parks, schools, open spaces. This is really a district made for these uses, for these important parts of our community, for these things that are often, done by taxpayers or done by charitable functions. Just trying to make a set of regulations that balances our interests as a public body in regulating and public safety and public welfare, and trying to make these very important things work in our community. Now, we've been doing this process for a little while, talking about this. The year is 1997. I won't tell you what I was doing at that time, but it is a twinkle, a gem in the eye of the Plan Commission at that time that there should be a public lands classification for users like School District 65, like the Park District, like the village itself. So this has been a long time coming. It's almost old enough to drink. We started this particular review, we started really going down the road here in January of 2016 was our first discussion about it. That was actually right before I started my employment with the village. We've really been focused in some deep study of these issues, of these individual parcels for the past year. We've tried to keep the most affected agencies in the loop throughout the process, including the Park District, the School District. Definitely we sent notice to everybody who would be affected a little bit over a month ago to give them plenty of time to review these regulations and to come with comments. Some of those are included in your packet and were posted online. And we've also had, I think, public outreach to be proud of. Every person in the village had a heads up. Well, not every person in the village, I should say, but certainly the 1,500 some people that receive our email newsletter had this top line, in our top line on our website, top line on our Facebook. This might not be, this is a technical issue, so certainly it's a bit intimidating to be involved in, but we wanted to make sure there was no doubt that we want people to be aware of this and to be aware of this accomplishment, and also we think a net good for a lot of different people in the village. So in short, some of the issues we're trying to resolve here, one, land uses for these, in these lands, in these areas, not necessarily predictable. The underlying zoning is residential, so in a very short amount of time, relatively speaking, there's the potential that someone could seek to convert these uses into residential uses without maybe the oversight or the involvement from the community that we would like to see. Another is that, again, these regulations being for residences, there are facilities like schools, like the community center or the recreation center that we're evaluating with the same ruler we made for a single-family house, and that's not ideal most of the time. And then finally, a procedural burden for applicants. There's a lot of steps you have to go through to get the exceptions you need to all these different rules. I'm not going to go step by step through these. These are illustrative. Today, there's probably 13 different steps if it goes well. You make your plans, we look at your plans, we look at your plans some more, we approve them. In reality, it probably goes something like this. You make your plans, we look at your plans, we say that there's a need to do something different, so you have to go back, do this again, you come here, and it goes on and on. From your perspective, from the perspective of a user, the issues are, again, we're doing everything relative to a single-family residence. That's our yardstick. And we're asking for all these different forms of really technical forms of relief, special use permits, variations, things that take attorneys to draft this Stillwell, but that really have a lot of burden. Oftentimes you need a whole team to navigate through this process. And from our perspective as a village, we're not involved up here. We don't have the chance to really interact when people are making long-range facility plans, when people are making master plans for parks. One of our goals through all this is to try and get more involvement at that stage, at that initial stage where hopefully we can see some of these things that we want down here and save everybody some time and also make better products for our residents, for the village. So this district has some solutions to these needs, right? First, land uses are unpredictable. If you're making changes to land uses within the Rio district, there's some review of that. If you're changing it to something not a Rio use, you're talking about a rezoning, which has considerably more public notice, public involvement, as you're seeing right now. Mismatch between regulations and uses. We've made these regulations from the ground up specifically for these types of land use. And then a procedural burden, you're never going to be completely rid of this. You're never going to have a process that has no public involvement, but we want to try to make this painless, try to understand that this is really taxpayer funds we're spending in a way, indirectly, and try to respect that and respect the time that people want to spend improving our village, ultimately. These are some, I'll skip this, these are some objectives from the first page of the ordinance where it talks about maximizing predictability, providing these important public amenities, enhance our village, enhance its features, and again, try to create some procedural harmonies. When we started doing this, the trouble was really trying to balance three competing goals. A few you might recognize this diagram. The first is, how do we see something early on? How do we see it at a time where we can influence the final product? The second is, how do we see something concrete? How do we see what's actually going to be built? How do we have some fine-grained control over the little things, like maybe where a loading dock is, that really have a lot of effect on neighboring properties? And the final is, how do we do both of those, but keep this easy, keep this simple, not have people coming in and out of Village Hall like a revolving door? Our solution to that was this idea of the Rio development plan. The easiest way to understand how it works, I hope, even if you're not an attorney, is just to read the section. I know that's intimidating, but part of what we tried to do was make it human readable too. But what we've tried to make is a tool that really solves for all these existing conditions. Zoning a lot of the times really starts with assuming you've got a bare piece of land and development's coming in afterwards. But most of these uses are already in the state that they'll probably be indefinitely. The school's already built. The community center's already built. And so how much you try to adapt to those existing circumstances is complicated. So we made a tool that tries to get around some of those issues by just authorizing deviations. We've tried to make a tool that has the flexibility to just deal with one little project if there's one little change, or for some of our bigger users like the Park District, try to authorize a whole 5-year or a 10-year master plan so that they can go and execute that plan without having to come here every time. And then finally, again, trying to align all these requirements. I'll skip ahead a little bit. So the idea is that, we approve this development plan, and that's the foundation for a whole program of changes that come after it. If you're looking at the procedure now in this little flow chart, you can see we're down to 9, but really, the PCZBA's involvement is all up here. It's all in the interaction between, these users' long-term plans and facility plans, and then trying to make sure that we've done our job, we've done our oversight, but we've done it up front in a way that agencies can then execute on what we've already seen, trying to encourage that long-term planning. So the other provisions pale a little bit in comparison. They're really oriented again towards new uses, new development, things that won't be terribly common in the Rio District. There are some bulk regulations that are relatively conservative, that are built with the considerations of these uses in mind. So, we have a good tradition of having very big buffers from highways in the village. We're keeping that alive. We've added new special yards around residential districts because we know that transition from a institutional use to a residential use might be the most sensitive area on that whole parcel. Signs, this matters a lot for our users. We've basically kept the regulations that are there today, not really proposing a whole lot of changes. And then parking is kind of an interesting one too. During our review process up here, we looked at studies that say, for example, the recreation center should have hundreds more spaces than it does right now, But in reality, we find that just because of how walkable the village is, just because of the ways people get around our village, typically, our sites tend not to need a whole lot of parking. So there's some reduced parking requirements, but again, there's the flexibility to not have to build to that full extent. And then finally, just a few things to underline here quickly. The first is our goal is certainly not to erode the protections adjacent property owners have. It's to still make sure they have notice and can participate meaningfully in things happening next door in a way that respects their time and respects time of people doing work. There's still notice, there's still public review. And again, these rules are a big change from what's built today, but there's all these different grandfathering provisions that make sure we're not creating a burden for these users when we flip the switch. As I mentioned at the start, we tried to engage the public and our stakeholders throughout this process. We received at least 3 letters along the way that are included in your packet. The first is from the Lake Bluff Park District, mostly with some technical recommendations. A couple of those we recommend that you consider and approve as part of this, shortening the time frame for minor changes to a plan, shortening the time frame a little bit for that to be considered. Most of these things we think have just as much to do with explaining the ordinance and showing how we think it works as they do changing and constructing. Similarly, from our water utilities perspective, their biggest concern was perhaps that they would be in a different group, that they would be treated more restrictively under these rules. And we made one change to make sure that they're always considered a public agency, just like the village, just like the Park District, that we plan to keep them on a level playing field. And then finally, we had a comment from Miss Stephanie Bjork, who I know is in the audience with us today. And I know Village Attorney Schuster will speak to a little bit as far as this idea of conservation easements, which are contractual agreements that set aside land for public use in perpetuity. I know Ben's going to give you a good treatment of that, but I wanted to say up front too that the whole point of this district is to preserve these public uses for public good indefinitely. By being zoned into this district, our hope is that we've made all these regulations to keep these public uses going. That's a big part of what we're trying to achieve.
Thank you. So, as you saw in your packet, one of the issues that was raised was conservation easements and other various restrictions and covenants that may be on property. So I actually just had a conversation with Ms. Bjork, and I will not steal her thunder, and I'll let her raise her concerns and issues. But to give you kind of an underlying focus on the law, just to be clear, the issue of easements, restrictive covenants, and other restrictions that may be placed on property, usually at the time that property is transferred to a subsequent owner, that runs independent and separate from zoning. And the intent of this exercise has been never to change, alter, extinguish, nullify, whatever word you want to use, any restrictions that are, covenants, easements that may be on property. And under Illinois law, the law is quite clear that zoning does not nullify or supersede a easement or covenant. And it's the most restrictive regulation that is going to apply. So, for example, and reading from a particular case here, but Shelley versus Villa Park Trust and Savings Bank, restrictive covenants do not supersede, enlarge, or diminish the requirements of whatever zoning ordinance may be applicable. And if the covenants are more restrictive than the zoning requirements, they prevail as to purchasers. If they are less restrictive, the provisions of the zoning ordinance prevail. So the idea is they really run parallel to each other, and that regardless of what zoning is granted, somebody is not free to violate restrictive covenants and easements that are placed on their property. The parties who have the ability under that document to enforce can certainly do so independent of our zoning authority. Similarly, if we have a property that has very loose restrictions on it from easements, or maybe no easements or at all, the zoning is certainly going to govern. But the point is they run parallel, and what we're doing does not nullify or change a conservation easement in any manner. It does not lift those restrictions, and a property owner would still be required to comply with whatever covenants and easements that are on that property. So, if you have any questions, I'm happy to answer questions.
I solemnly swear I only have 2 more slides, and that's maps. So I thought we were done here. I got 2 more for you. So the other part of this public hearing tonight, again, separate ordinance, is map amendments. So putting property into these regulations we just made. There's a lot of stuff moving around. 200 parcels. At least, I didn't do the area math, but it's got to be somewhere in the neighborhood of 1/4 to 1/3 of the village by land mass is probably moving around as a result of this. We've had an interactive map up on the village website for everyone to be able to see what's going on. The actual published legal notice it's like 3 pages long. It's great. Not really. So just to give you a bit of the flavor for what we recommended, our criteria for staff is recommending what to include is the same as what's outlined in the ordinance. So we're looking at use, again, very important. Ownership isn't use. Use isn't ownership. They happen to be close here, but use is really our driving criteria. So what's the use today? What's the suitability of this land for the uses permitted in a residential district? Most of these are being rezoned from residential. What's the impact of existing zoning on the developments that can happen here? What are the trends nearby? What benefit does changing zoning districts give the property? And then finally, not super applicable here, but how long has this been vacant compared to other properties? This is probably, our rationale probably illustrated a little bit better just by example. So you can see down here in the, in what's known as the, I'm going to do a bad job with the title, you'll forgive me, the Skokie River Land and Water Preserve. Close? Close enough. We've included all those, including, and I should mention here, a couple lots that have stayed in private ownership. Since we're moving into the parcel by parcel discussion, I will note I heard from one owner of one of these private lots that is displeased by this change and feels that, you know, the village has worked over an extended period of time to prevent a house from being built on that lot. We should mention this is floodplain at this point. This is a protected nature reserve, but that's out there as an example. You might note as an alternative comparison that here in the central business district, the community church's offices here, we're not recommending you rezone. Both because, one, we have good central business district, we have rules well developed for that district, and also the church can move out of here at any time, and we think that should still be able to function as an office when they're done. Rezoning it doesn't really give them a whole lot of benefit. It's arguably to the detriment of, you know, the continued development of this office building as a whole, for example. So we can give some more examples like that. Again, we've tried to be very considerate of, from a practical standpoint, what makes sense to put into this district. So I've only talked for 15 minutes, but it feels like a lifetime. Happy to hear any questions from the group or from the public.
Well, thank you very much, Mr. Cole and Mr. Schuster. Excellent overviews from both perspectives. Any comments or questions from the commissioners before we take public testimony? All right. My thought today is that we would allocate 10 minutes per presenter. I think that should be adequate. I think it also should be known that all the submissions are incorporated by reference into the record, so to speak. So we're all set. Whoever would like to approach first, that's fine.
Good evening, Ron Solsky, excuse me, Lake Bluff Park District. Take 20 seconds. Thank the staff. They did a terrific job on this, and when we provided questions to them from our attorney and landscape architect, we were very pleased with the responses that we got back from the village attorney as well as staff. So we like the small things such as playgrounds and things like that, where we can just go ahead unless it's outside the scope of what the current footprint is, and we understand if there's changes in buildings and things like that, structures, that you're the first place that we should come to and be a part of our planning process. So we're excited to move forward with this and have really no other comments.
Well, thank you very much, Mr. Solsky, and thank you for the Park District's participation during the pendency of this. Much appreciated. Anyone else? Yes, ma'am. Good evening.
Good evening. For the record, I'm Eric Bailey, Director of the Lake Bluff Public Library. Just very quickly, want to express my gratitude to Glenn Cole in particular and the PCZBA and in general for all the hard work that's gone into this. My perspective is it's very well thought out. Glenn came over, sat down with us, took the time to really go over and explain how this would apply to the library and go through the details. I don't have any follow-up questions at this time. Mostly we're just very excited. Having been through the existing process a few times, which requires for a lot of different items, amendment to the variation under which we operate. We're very excited for to have the new zoning in place. So, only comment, library supports the change.
Thank you very much, Mr. Bailey, much appreciated. Ms. Bjork?
We'll all be glad when this process is behind us. My name is Stephanie Bjork. I'm on the home at 414 East Prospect. I have one more thing to pass out to all of you tonight, which is an article on public access to information on private land for conservation tracking and easements. There's 10 copies here, and you guys can pass them out, Chair. I also submitted 3 articles that are in your packet for tonight, and I have to say I'm here to represent the taxpayer interest in all of the properties that have been put into easement and essentially paid for by the taxpayer in large part. The library, several of the churches. I haven't seen the underlying documents for the Park District, but these are, in a large part, 501c3s, which are federally controlled, and there's documents underlying those with terms and conditions, and that's exactly what Mr. Schuster was speaking to you about earlier, that you don't have any input on those underlying documents. And I understand that the need for expedited, additional development, expedited systems, I understand why this is coming to the fore. But to Mr. Cole's original comment of the triangle, I'm going to start with the first piece. The first piece is that I FOIA'd of the parcels that are listed, I FOIA'd for all of the underlying easement documents. The underlying easement documents control those properties in perpetuity. Those were signed off on by the village, by the taxing bodies, by the federal government, by whoever the 501c3s are that hold them, and those are out of your hands. So what I asked Mr. Schuster this evening, and what I asked the board a month ago and a year ago, was to do the research, pull those documents out, see what you were dealing with as a board, know what you could change, know what you couldn't change. And my issue tonight is that I feel in the state, you have the right within 500 feet in the state of Illinois, which is unusual, to be a third-party enforcer for a conservation easement. And the only way those who with a right to enforce will know is if those are documented. And so to say that we're not changing anything by overlaying this rezone or whatever changes are made is all well and good, but I'm probably one of the few people in the state of Illinois that knows where these easements are. Because of our court cases, I know the easements, I know the documents, I know where they are. And the general public does not know that these even exist. This is a very complicated tax structure that is very serious, but it's not something most people would have any reason to understand. And so it's still their right, and they've still paid for it, and I am absolutely passionate that these need to be, that they need to have the right to enforce, should they choose to. And the only way they can do that is to know what the terms and conditions are on each individual easement, because they're all very different. And so tonight, many of the things that are being discussed as being allowed to be changed, whether it's changes to facade or additional building or any of those issues, may be strictly prohibited in these documents. So here's to the point that it gets complicated. I understand the village would like to see an increase in development in some of these areas. I understand that current owners might wish different uses. And I understand that it generates revenues and fees that cannot exist now, but it's prohibited. And so, as I told Mr. Schuster, a very important case just came down with the Palmolive building downtown, that the mortgages were not properly subrogated to the document, and they owe $33 million back. That happened within the last month, I believe. I think it's probably still pending appeal, but it's a substantial wake-up call. And the penalty, according to the IRS, for violating the easements is not on the current owner who violates. It's on the original easement, even if that's an estate. So you've got people that did all the right things, that obligated their land and wanted it maintained that way and kept their promises to the taxpayer, and subsequent owners aren't really, that's not their interest. But the penalty goes back to the original owner. So as I said to Mr. Schuster, my concern is that there's not really, I don't feel there's an awareness on the board of the liability to become involved in misrepresenting what can be done with any of these parcels. And I believe that by not literally carving them out on your map as white spaces that are no-go zones and disclosing those easements, there's no way for you to avoid the impression that you're allowing something, because when this comes up to a neighboring homeowner, all they're gonna know is, oh, the new zoning allows that. They're not gonna have any idea that there's an underlying document underneath there that they have right to enforce. So disclosure and transparency is incredibly important to me, and I see it as a liability to the village to take a position against, as the documents I've given you, against the head of the IRS who handles conservation easements, or Nancy McLaughlin, who has written all the guidance currently for them. So those two articles come from people that are at the very top of the rules and regs. And I understand this is kind of raining on your party, and I apologize for that, but these easements won't exist in perpetuity if they're allowed to be chewed away at. They just won't. And I really do think a lot of good people did a lot of beautiful things that the taxpayer supported, and it's an important principle. I appreciate Mr. Schuster speaking to me tonight before the meeting, and I don't assume that there's any, at worst, a lack of understanding of really what's involved here. But I think it does substantially misrepresent to not do the first step, find these easements, see what you're dealing with, see what your options are, and to not wade into that water if these homeowners want conditions changed. That can only be done in a court of law, and that needs to be done by them, and they need to take that into court and see if they get that authorized. It's not up to me, but it's not something for the village to facilitate without, I think, a substantial liability. So I appreciate your time, and I hope you give it some thought. I would hope tonight, to be very honest with you, I would hope at the very least this gets tabled and looked at, because I really don't think there's an understanding. And I spoke to a developer and several neighbors who have no idea, had no idea what this discussion was going to be about tonight. As you said, this is a very complicated issue. So I would hope at the very least you would pause and really try to comply with what the law is. I thank you for your time.
Thank you, Ms. Burke. Any other comments or questions from the public? I would.
You don't need to make a, say that, but you can, if there's questions or deliberations by the commission, you can certainly do that. And then it would be up to whoever wants to make a motion if you feel that you're ready to do that. I will also say that you have two different things before you tonight in term, that would be two separate motions, two separate votes, if you decide that you'd like to vote tonight.
Oh, Gary, I definitely have comments and a couple questions.
Oh, certainly, certainly.
Sounded like we were maybe going to jump right
Oh,
to a
no, no,
motion to
no, no.
approve.
Nope, no. Mr. Schuster, did you want to respond to Ms. Bjork's comments, or?
Sure. So she's raised some significant issues in terms of tax treatment of conservation easements, education of the public in terms of what their rights are, property owners nearby, and what their rights may be to enforce conservation easements. And, you know, and I think that the way that I think the way that I would recommend that you look at it is, again, I think that the conservation easement issue is significant, but in one that I think does deserve attention. But it is a issue that is parallel and separate from the issue of kind of what you're considering tonight. Again, whatever you choose to do, one way or the other, does not nullify, does not change, does not alter the effectiveness of an easement. And a property owner, whoever that property owner may be, that owns properties that has a restriction on it, has a contractual obligation in order to comply. You know, and so then certain people have a right to enforce, whether it's members of the public, whether, you know, it's certain public bodies, whether it's the person who granted the easement. But that is really a separate issue from the underlying zoning. So, you know, again, just because we change the zoning does not mean a property owner is free to develop the property for any permitted use. They may have significant restrictions that prevent that. Also, each property, it's a separate analysis because conservation easements and other types of easements and restrictions may be different property to property, and what may be permitted and what may not be permitted. So you have to look at each underlying document to determine the bounds and restrictions that would apply. But again, ultimately, what's before us tonight is the issue, number one, of the text amendment, of whether you think that it appropriately creates and defines a Rio district, and then the second issue being what property should be placed in it. The other option that you have is if there are particular properties that you desire more analysis of or questions about, you can continue this to another evening. You can make a recommendation on certain properties. You do not have to do it in an omnibus fashion where all the properties before you go in to a Rio district together. It's up to you on what recommendation you would like to make.
Thank you very much. Yeah, in this instance, with respect to both agenda item number 5 and agenda item number 6, the commission is a recommending body. And my thought is that we address the draft Rio ordinance first, discuss that, and then we'll discuss the various parcels. So, Mr. Badger, would you like to start?
Chairman Peters, is it an appropriate time to just comment on Ms. Bjork's comments and just put on the record a few thoughts on what she's brought to the committee tonight, or should we have those comments later in the evening?
Certainly fine right now, Mr. Murray.
So I want to thank Ms. Bjork for her comments tonight and for the obvious efforts that she has extended. I share the overarching concern about ensuring that whatever actions we take as a committee, as a recommending body, but also I hope very much as a village board that we make every effort to really reflect the underlying intent of individual landowners who have taken steps to preserve their properties for, the long-term benefit of the community. I think that that's an essential part of decisions that have been made over, frankly, years, if not decades, to preserve parcels of land which are important to the enjoyment of our common spaces. I would say that as a member of the committee, I am interested very much in understanding the implications that are raised to these underlying questions about overlapping jurisdictions and whether changes in zoning could, in a way, interfere with the underlying gifts or acts of the landowners who have provided easements for the public benefit on these lands. And I would just ask, officially, that as a committee, we receive a readout from the village staff as to the underlying question here, which I understand to be whether or not there is, not in the general construct of the Rio ordinance, which again is more of a framework, and not even in the general principles here, which are to provide, I think, a greater degree of oversight on behalf of the village towards any change in the underlying purpose of a given parcel of land. But I'd like to understand from the village staff whether or not any of the actual rezoning efforts, which I think are under agenda item 6, whether or not that could have an implication if indeed Ms. Bjork's comments are determined to be a governing aspect of the law here, whether or not agenda item 6, as opposed to agenda item 5, is something that we may want to put off to more fully consider in the light of this question of underlying easements, and whether or not that places zoning out of the jurisdiction of both the PCZBA and the Lake Bluff Village Board.
Thank you, Mr. Murray. Mr. Cole or Mr. Schuster, would you?
Yeah, so to respond, I don't think that it's a matter of a jurisdictional issue, because you certainly have the right to zone the property as you see fit. And again, I don't think the zoning is going to, I say the zoning has no impact on the easements themselves. I believe the issue, and again, I do not want to put words in Ms. Bjork's mouth here, but it's really, I believe her issue is one more of education and transparency to the neighboring property owners and taxpayers and residents in terms of what the easements say, which properties are encumbered by the easements, more than it is an issue of the zoning itself, or perhaps her view is that somehow by changing the zoning, it may give an impression that somebody has a right to develop land, in a way that contravenes the easement. But from a legal perspective, you have, the jurisdiction to change the zoning, and that zoning has no impact on the effectiveness of the easement. If you wanted to zone a property, and this might be an exaggeration perhaps, or hyperbole, but if you wanted to zone a property for a 100-story skyscraper, it would have no impact on whether the conservation easement requires it to remain open lands and whether a skyscraper can be built. If there's a conservation easement, one would not be able to be built on there based on that underlying document. So I don't see I do not believe there's any issue if you wanted to change the zoning of these properties to the Rio district. Of course, it's a policy decision of whether you think it's wise to do so, and whether from a transparency standpoint, from a education standpoint, if there are other things that you think should be done, that certainly that can happen. But again, that's a separate issue from the zoning.
Thank you, Mr. Schuster. Mr. Cole?
Sure, I'd make 2 comments. So the first, overarching, before we get into discussion among the commissioners. Certainly, I would say there's no pressure to conclude this hearing tonight or to make a recommendation tonight. In fact, in our discussions as staff, we would go so far as to recommend not closing it tonight. Again, this is one of the biggest zoning changes in the history of the village. we don't think it does any harm to take the extra month and make sure nothing else floats up out of the ether or after people have taken additional time to review what's in front of them, especially given the proximity of the holiday and how technical some of this material is. The second point I would say, certainly we've had some passing conversation about conservation easements in the context of the comprehensive plan. That's probably a good place for this discussion to live from a policy standpoint. You know, I don't want to dive too much into this because as Mr. Schuster said, excuse me, it is a separate issue, but I do want to emphasize that I can't speak for the village. Speaking personally, professionally, I would love more transparency around where these easements are, how people can enforce them. I think that's an essential part of public policy. I would point out that this whole paper Ms. Bjork handed out is very instructive, at least in the brief skim I just gave it, but it's about the challenge of doing that. It's specific to California, a state that has done enabling legislation to try and make that easier. And the authors, I'm quoting page 1271, say, "We recognize that compiling these data is a monumental task, but relying on a limited group of conservation easement holders to self-report doesn't provide a comprehensive picture either." You know, we as the village, we typically don't get notified when these things happen. It's recorded with the county. Perhaps Shields Township finds out as a tax assessing body. We usually don't know. We've invested considerable efforts, for example, into researching the Crabtree Farm parcels and the overlap of easements in that area. I've got a binder if anyone wants to borrow it and is interested. Certainly, we as the village control some or are named parties in some easements, such as in the Stonebridge development. But by and large, you know, we can certainly allocate resources to it and work on developing it, even incrementally, a database of where these things are, trying to add some of that transparency. But I would definitely emphasize that is not a simple undertaking for anyone.
And I'll also add, to the extent that the village has the authority to enforce these easements, changing the zoning does not somehow waive our right to enforce. So putting it in a Rio district where a particular use might be permitted does not mean that we wouldn't be able to say to that property owner, as somebody who has a right to enforce the easement, I'm sorry, we are not going to permit you to build that building or engage in that use. We will enforce the easement. So again, I think they do run, while incredibly important, they are a separate legal issue.
Thank you. Thank you, Mr. Schuster and Mr. Cole. Mr. Badger.
Thank you. I don't have too many questions tonight in particular to the documents, but I think I was curious to see, obviously the Park District was here, and I read an extensive letter from Jawa in response to the new zoning, and obviously the public libraries here, but have you had much conversation with the school district or the churches or ComEd, or what have their reaction been to when they've been alerted?
Sure. So the whole list of conversations, the letters you received in your packet, I understand Village Administrator Irvin had a conversation with Grace United Methodist Church. I'm not familiar with what was discussed there, but no written comment. The conversation with that one private property owner in the reserve that I mentioned, that's really about it. I know that I've gotten responses from the school district just saying acknowledged or thanks for keeping us in the loop. Mm-hmm. I know we met with them personally earlier this year and talked about this. I know we offered them a meeting again more recently, now that we have a full proposal, and they didn't see the need to meet, I believe. So that's about the extent of what we've heard from the public or from affected landowners.
That could be a result of the school's already been built. Nothing is really new on the horizon, where the Park District might fall into a different category there because they're continuing to improve the facilities. ComEd, you know, these other folks, you know, it's just
Nothing.
nothing. That's all I have at the moment.
Switch over to Member Russell.
Took me short there. I thought you were going to go right down the line. I
Everybody
think,
on the edge of their seats, right?
I think one of the fundamental things I heard tonight that I think is not correct is there was a statement made that this RIO ordinance, that we're doing it to support an increase in development, and nothing could be further from the truth. The main reason I'm excited about this ordinance and want this ordinance to fall into place is because there are literally dozens and dozens and dozens of smaller open space parcels that are owned by the Park District, that are owned by the village, that are zoned residential. And Ron, don't get upset when I say this, but there could come a time where a rogue park board could, 4 members of that board could decide they want to raise some funds in a hurry, and they could take the steps to sell off some smaller parcels. And if they remain zoned residential, it wouldn't even come to us unless they were seeking a subdivision. I think in Mr. Cole's or Glenn's excitement to sell all the wonderful benefits of this, we're making it easier for very small changes to occur. Right now, because all these properties are zoned residential, you can't even put a little awning on the clubhouse in the middle of the golf course, hundreds of yards away from the nearest home, without it coming to the PCZBA for approval and the Architectural Review Board for approval. It's still going to go to the Architectural Review Board, but we want to make these little tiny changes easier to occur. But it in no way supports an increase in development. In fact, it does the complete opposite for everything but the smaller changes. And then, Mr. Slawski, just to clarify something that I heard you say, you made the comment that you understand that if the Park District rebuilds one of your existing structures, that you'd have to come before us. The good news is if the ice rink building, which is getting old, if that would have to be reconstructed and you decided to put that in the exact same spot, on the exact same footprint, at the exact same size or smaller, you wouldn't have to come to us any longer. You could just go to the Architectural Board of Review. So those are good things. We're trying to eliminate the bureaucracy, but we are not. This does not, and I wouldn't support it if it was for an increase in development. And then, Glenn, could you go back to the second or third slide that you put up this evening that listed the uses? Can you roll that back when you're?
Certainly, just to make sure. Mr. Murray, are you back with us?
I am. Thank you, Glenn.
We had a brief disconnection. We've resolved that. Turns out dialing in from London can occasionally be a little unreliable. Was that the uses slide you wanted there?
Yes.
All right.
There you go. And the bottom bullet point there is the one that I want to address. Some of you may remember that 2 and 3 meetings ago, I was lobbying to get the terms open space in the use table. And in our last meeting, we had it in the use table, and it's dropped out of the public hearing copy of the use table. I don't understand it. Open space in this community is very, very important. To me, it is a use. We're saying it is a use. It's in the title of our document, open space. I think the term open space ought to be in our use table. Open spaces should be permitted. They shouldn't be listed under recreational facilities. There's a difference there, and I don't know why we wouldn't want the term open space put back in our document, particularly since our document is called an ordinance amending the zoning regulations to create recreational, institutional, and open space districts. So I just think that's a fundamental change. Maybe I'm making a bigger deal of it than we should, but I just think that term should be there. We have an abundance of open space, and this document protects it, and I view open space as a use. And then the last example that I just wanted to cite, it's more of a question for staff and for Ben, an issue that I was harping on earlier in the development of this. I wanted to make sure with the concept of the development plans that have to be, or sometimes need to be created, that when the park district or the schools, in particular, the two biggest landholders in the community besides the village, when they go to do a project, if the golf course clubhouse, now that we have, the park district has a new agreement, they're gonna run hopefully the golf course for 5 more years under this new agreement. Hopefully it'll take off, make money, and the golf course can remain. There may come a time where the park district wants to build a new clubhouse. I want to make sure that when the time comes, even if the clubhouse is bigger and they have to come before us, that staff and the village attorney isn't going to rule based on the language that the park district has to submit a survey of all 200 acres of Blair Park in order to move a clubhouse project forward, because that would fall into the same theme of trying to eliminate bureaucracy. And I don't know that it is absolutely crystal clear in the language that we have. I know I've been assured that good common sense will prevail, and of course, we won't make the park district survey the entire 200 acres of Blair Park in order to build a clubhouse that's, 10% bigger than the one that's there and would trigger a need to come back here. I don't want all that unnecessary documentation to be forced upon the other municipal entities.
So I would direct you to section 10-16-7B of the proposed ordinance, and it's the application requirements. And what is required is the same requirements for the site plan review, but importantly, if you keep reading, it says, upon request, the building commissioner may exempt an applicant from including in its application any required items if the building commissioner determines that a required item is not applicable or necessary for consideration of the application. So that's the perfect example where a small change to one small portion of a property would not, where the building commissioner can say, oh, it's not needed that you provide, whether it's a survey or any other requirement for the entire space. The building commissioner would have the authority to be able to say, I'm going to waive these requirements, because it's just not necessary or applicable. So there is the freedom there to be able to do that.
And Glenn, as the current staff member and enforcement officer, do you feel when the time comes
I
and Ron
solemnly
moves forward with
swear.
a new golf course clubhouse, that common sense is going to prevail and we're not going to require these extensive development plans of gigantic parcels when only one building is being modified in one portion of the parcel? It just would make utter nonsense to me to require someone to do a complete development plan of their entire parcel for one smaller change.
In the case you're talking about, I agree completely.
Okay,
I can't
good.
speak to
You're
every
on the
case.
record, so as long as you're alive, we can come after you. And I think other than that, I had no issues. I know, Glenn, in your letter back to Mr. Solsky, I had no issues at all with the few changes that you were recommending that we make. I don't know if you were going to go through them or not, but I'm not opposed because they were all smaller, common sense changes. I don't know if they need to be read into the record or not if we approve this tonight.
Yeah, so a couple notes real quick if I could. We've got there were small changes. What they were in substance was said in the memo. We have a red line for you at the dais if you want to be perfectly sure. The language Mr. Russell was referring to is highlighted here.
And I don't, all those extra words at the end, I just want the term open space there. But
but we have no objection to it.
Thank you.
Okay, and then, I'm sorry, just a final comment on the issue of the conservation easements. As I understand it, and everything that Attorney Schuster has explained tonight, it is a completely separate set of regulations. Just as one can make the argument that the village should go through all 200 of these publicly owned parcels and try to do a title search on every one of those to uncover every one of those easements, it would be a monumental undertaking by staff to do that. Monumental, if you can imagine doing a title search on all those parcels. And the same argument could then be made next month that, well, by golly, we ought to do it for every residentially owned parcels, because there are many conservation easements on residentially zoned parcels that aren't being changed. It's a completely separate issue. I agree that it would be great to have all of these publicly identified, but what we are doing tonight in no way, shape, or form affects the status of that separate issue. So, I mean, I would be in favor of approving the, moving forward and voting to recommend approval of this tonight with the minor changes we've talked about.
Thank you, Mr. Russell, and thank you, Mr. Badger, for your earlier comments. Member Burns.
Well, in the sense of, or in the intent of efficiency, I'm going to try not to restate a lot of the comments that Member Russell said, but I'm very much in agreement, in particular with his comments regarding the intent and it not to be for development, but to rather preserve what we have with the uses that are being used today. And I think that also speaks to the easement. Even though I do agree that it's two separate things, I think it actually does a better job of protecting those with the conservation easements, because what could be done today, as Member Russell said, we wouldn't even know happens. You could be building houses all over the places without any notification or anything. So I agree again, I agree in the information availability. I think it's a good thing. And if, technology ever came along that it would make it easy to do, we should definitely go for that. But I think they are two separate issues. I'm very much in favor of this ordinance. I think it's doing the right thing for the village. There was one clarifying, I don't know if it's a typo or maybe it's a slight misunderstanding, but I'm looking at page 12, 1016.7, the bottom of the first paragraph under Rio Development Plan Review. It says, at the end of the sentence, unless exempt under section 1016.7.e, and I thought that might have been referring to F, unless I was misunderstanding the exemption piece. Because E speaks to authority to modify regulations, whereas F is exemptions.
I believe you are correct, Mr. Burns.
Okay, just checking to make sure I was understanding correctly. Otherwise, I'm very much in favor of this and would vote for recommending approval.
Thank you, Mr. Burns. Member Murray.
A question, an underlying principle as we've considered the Rio ordinance, really from the beginning, has been this construct that we want to put process, and I go back again to some of the public comments here around transparency and process as being checks to, in provident development of the land in question. I think that I would say, Mr. Chairman, is that, I feel that through the various revisions of this ordinance, which was certainly under revision long before, I took my seat on the PCZBA, and has continued for the past few months, that we've continued to develop the language to ensure that level of scrutiny and transparency and process. So at this point, I would just say that I feel like as a framework, and I'd separate out the agenda item that follows. But for this particular agenda item, I feel that the framework really does provide the ability for this body to scrutinize any repurposing of these essential parcels of land as we, as a village, really deem fit. So, at this time, Mr. Chairman, I don't have any further questions for the village staff, and I look forward to hearing what my fellow members have to think about the ordinance as presented.
Yeah, thank you, Member Murray. As you most eloquently stated, we have spent a considerable amount of time working our way through this ordinance, or this draft ordinance, I should say. And one of the positions that I've taken during the pendency of this is that obviously we're trying our best to have the best ordinance possible, but if there is some deficiency that's identified down the line, assuming that it is passed at some point, we also have the opportunity to make changes going forward. So I think the framework's in place. I think it's very, very well drafted. Any other comments, Member Murray, for right now?
No, thank you, Mr. Chairman. I'll await the call to a vote.
Thank you. Member Danley.
I've just been sitting here thinking of agreeing with much of our other members here, and there's something that we have to remember is why we're doing this, and it's really is to secure the land uses is one of the main reasons, is really to secure and take value and hold of what we have. And like Member Russell said about giving a few examples of how the ordinance would streamline the process, that also is really important to be reminded that we're here to help facilitate something that could be very beneficial for everybody involved. And I think the easements, as much as I want to read all of this and learn more about it, I can't help but think that it is running parallel, and I don't think that, as much as it's a hardship, I thought, well, perhaps we can get a transparent overlay and see how many easements there are in the village. And I think, again, that's overwhelming for us to really even begin to ask that of our staff. And I could only hope that what we would do, or anybody that has an easement or something in their effect in their property line, would have to go through the same varying degrees of understanding and seeking approval or changes. So, especially approved by law. So today I would definitely vote to approve this ordinance and appreciate all our work.
Thank you, Member Danley. Member Miller.
I'm in agreement with all that's been said. What puzzles me now is if we do go forward, or if we postpone, Village seems to think that maybe we should postpone, from what Mr. Cole said, but we have been working on this for quite some time. The concern I have, now that we've put this in public, are there other people in the public out there who will attend the next meeting to give their views, now that this is a public forum? And maybe, as much as I like to finish this up, maybe we should wait a month and see if there's any more communication from the village, from the people who live in the village. But I'm in agreement with this as it stands now.
Thank you, Member Miller. Yeah, over the past several months, we, as a group in the village staff, have spent a considerable amount of time working our way through the ordinance, attempting to better understand the ordinance. I think everybody's on board with respect to the conceptual understanding, and I think we're pretty much all on board with respect to the actual wording of the draft ordinance. Efficiency is critical, protecting the resources are critical, and I believe that the village has done a very nice job of putting this all together, obviously with the assistance of Mr. Schuster and his team. With respect to how we go forward, perhaps we have to discuss whether or not the timing is appropriate for a vote, or whether alternatively the matter should be continued to the next session. I'm certainly willing to engage in a discussion on that, to try to reach a consensus, obviously.
Well, I'm in favor and recommending approval tonight. This still would have 2 readings before the village board in order to get approved. I'm convinced that it is a very good document for the village, and once adopted, it only serves to protect against some sort of rogue development happening on an isolated parcel or two. I'm as important as, and as great as it would be to know where every conservation easement is in the village, it is a task that staff is just not going to be able to run through quickly, or even in a year, or I can't even imagine what it would take to do the title searches on all these parcels in the village. I'm not talking about just these 200, but all the residential parcels also. I just don't see the benefit in waiting. We're gonna have 2 public meetings in January at the village board level. The comp plan review is starting to get very, very stale. As Glenn noted at the beginning, there was lots of notice for this meeting, different mechanisms posted. I'm very much in favor of voting on this to move forward tonight. I just don't see a benefit in the month's delay, other than that it puts back our other work on the comp plan and other issues that will start piling up.
Thank you, Member Russell. Any further discussion?
Yeah, I'd just like to add to that to say, if there was contention among the members here regarding the content or intent or really any of it, or if it changed dramatically in this meeting, I would be up for postponing it, but neither of those really happened. I think the substance of the ordinance is the same as what we had presented, with a couple minor little tweaks, and I think we're all very much on the same page. So given that, I think I'm in favor of having a vote tonight.
Thank you, Member Burns. Any other comments from the commissioners? I guess just, it's clear from the record that considerable effort went into evaluating the draft document by the Park District, by JAWA, by other entities, and the village staff has expended considerable resources in addressing each of those issues and questions. And so from my perspective also, I think that the document is in the best shape that it can possibly be in at this particular point in time. And I would be a proponent of moving forward with a possible vote for recommendation. Do we have a motion?
I move we recommend approval of the ordinance as presented this evening, an ordinance amending Lake Bluff zoning regulations to create a recreational, institutional, and open space district with the few changes that have been mentioned, the insertion of the open space back into the use table, the minor correction that Member Burns noted, the 3 or 4 different changes, minor changes that we were all copied on between Mr. Cole and the Park District. I'm trying to remember if there was any.
So that part that's already part of the ordinance that is before you. So I believe the 2 that,
Okay, the newer copy.
the newer copy.
All right.
So I
So
believe,
just the 2 changes
so the
then.
2 changes would be the open space language and then the reference at the beginning of section 10-16-7. Just updating that reference instead of subsection E, it'll be to F.
Is there a second?
Second?
So move. Could we have a vote, please?
Just one moment. So, as always, the order is random. Member Badger?
Aye.
Member Russell?
Aye.
Member Miller?
Aye.
Member Murray?
Aye.
Member Burns?
Aye.
Member Danley?
I
Chair Peters?
Aye.
Motion carries.
Thank you. All right, agenda item number 6, which we've been addressing during the pendency of the public hearing. deals with the zoning map or amended zoning map. I guess we'll start right out and see whether or not any of the commissioners have any questions or comments with respect to that proposed amendment. Member Badger.
I do not have any particular question about the different properties. I actually asked earlier a little bit about the different owners. I do not have any questions about the map in this ordinance.
Okay. Member Burns.
Just one comment, and that was the green space on the map north of the V on Village Hall on Sheridan Road. That is in fact green space today, but it's kind of firmly planted in the middle of residential space. And I know that that was a topic of conversation during the comp plan as to what could potentially be done there. And I know there was some discussion, and I don't think there was a final decision on whether that space could be used for other things or not. But zoning it as Rio, I think, kind of makes that much more concrete.
What are we talking about?
It's the,
Further up north, I
Whoopsie.
think.
it's the space in yellow. If you could kind of push down
Oh,
that
yeah.
space,
And then further north.
and
also,
further
right?
north, yeah, and that space up, so
On
maybe zone out.
east of Sheridan or?
East.
East,
Yeah.
east of Sheridan.
The
Yep.
miscellaneous
Tho-
green
that
spaces that the village
And
owns.
that, and, well, I'll get up, which doesn't help.
Yeah, if you want to get up, and I'll give you an aerial as well.
It's these two areas.
Yes.
So I'm not necessarily opposed of keeping them green space, nor am I opposed, but last I remember in the comp plan, we talked about investigating whether it makes sense to think about that as a space for alternative housing or things like that. I know we've talked about the west side of it, which seems very impractical. I just don't know if we had come to a decision on that. I know there was definitely some disagreement on whether that should be considered for anything. So by putting it into Rio space, it's kind of, I can't imagine it would ever go back. So I guess my point there is if we're making that decision, it's kind of a comp plan decision, and we'd have to go back and be okay with that element of the comp plan being struck from that being a consideration, because I can't even imagine considering converting it from a Rio back to a residential use. Or if we think there's any question of using that for some sort of multi-use or residential use, then hold off on making this Rio until we've got a firm decision, and then we could put it into Rio.
Is Ragsdale included in that space?
We stopped short of Ragsdale, so this
All right,
is
so
the
they're in
line
okay.
here. Yeah. So this is roughly the southern area, and then it's on perspective just to add a little bit of depth, and then this is the
Yeah.
northern
The green.
area.
I have no
That's-
problem
but it-
including that.
It's currently owned by the village, correct?
Correct.
And if for some reason somebody thought maybe that was a great place to put up some sort of housing, they would have to be in its Rio zoning. They're gonna have to come in front of us. First of all, they're gonna have to own it, right? So that's a question by itself, because the village wouldn't do it itself. And they could, certainly, the owner can come in front of us and apply for a different type of zoning that would fit their application. So you're not necessarily shutting the door forever, but you are, essentially you're being consistent throughout the village and all the village's land of making it Rio zoning. So I totally understand why that's included in this map, so.
Yeah, I'm in favor of moving it into the Rio zoning. I personally expressed the opinion before, when I joined the Plan Commission, that I was opposed to the thought of changing it to something else. So all the stuff to the north, I think, is all single-family zoning. Any type of use from what's there today, whether we adopt Rio or not, is going to result in a revisit to this body in one way or another, unless the village would sell it for single family, then it could possibly skip over us, but, well, no, it wouldn't, because it's changing the use from open space,
Right.
which is a nice term to have in the document. So I'm in favor of having it, the map the way it shows, move it into Rio.
Yeah, just to be clear, I'm not opposed to that. It was, to me, more of a consistency, and I haven't seen the redraft of the comp plan, which may have made that more clear in our intent, but at one point, there was discussion of that being investigated, and I guess, I see Member Badger's point, too, that it kind of fits the definition of open space. I just think we ought to make sure that the comp plan draft that we have kind of comprehends that, because I think we're putting this space in along with just about any other Lake Bluff owned green space, then I can't imagine us commenting in the comp plan then that we'd consider that space as potential development space. So it just, to me, it's a consistency question.
I would, and we can keep discussing, certainly I would say that, if, you rezone it now, I think that's certainly defensible and good practice. That matches the comp plan that's in place today. That matches its current use. It has a lot going for it. If you were to not recommend that because you don't consider it a settled issue, I think that's defensible too. Let's say you do it and you want to revisit that decision. I mean, you have that prerogative to rezone land proactively, as we're doing right now. At that point, you'd be doing it consistent with what that comp plan would say about its future use.
Okay.
And you'd be in a hearing just like this.
Okay.
So I think you have a lot of luxury in how you want to approach it, or flexibility, I should say.
I have one question with, does Lillian Dells, the ravine, count as open lands?
Sure. So there's this is one of those maybe. Yeah. Well, it is open land. It is dedicated to the village as a pleasure driveway, quote unquote. I believe that counts as a conservation easement. That's the original wording. So in actuality, if you look, at least in this example of Lillian Dells, it's not actually a parcel of land. It's set aside as, if I can find it, it's set aside as a right of way. So they don't even make a parcel out of it. So that's why we didn't include that. There's a few other strip parcels and little undevelopable things where, you could include it if you wanted to. We thought it made the most sense, since it's a transportation use, or really accessory to transportation, that you
Leave it out.
that it doesn't do a whole lot functionally to add it or take it away, as compared to some of these parcels that could see development at a different point in time.
So if somebody wanted to pave Lillian Dells for whatever reason, would that have to come before this committee?
It would not.
Okay. If it was part of the Rio, would they have to?
I would
I'd have to
disagree,
think about
member.
it,
I would disagree, Mr. Cole. It's in a ravine and it would violate the zoning code.
Fair
It would
enough.
have to come to us.
Fair enough.
That's what I think.
You can't pave Paradise, can't pave Lillian.
Correct. Yeah, you can't do that type of work in a ravine, so it
I'll
would.
give you that. Yeah.
Okay. I don't have anything to worry about.
Good catch, though, because I had thought I had caught all the little parcels that weren't addressed on Glenn's map, and he had answered all my other questions earlier in the week, but I somehow missed the Lillian Dells.
That's where I run by, so.
Yeah, thank you, Member Burns. Mr. Cole, if you could just make sure that the record properly reflects Mr. Burns' comments, so that when we get back to the comprehensive plan, we can follow up on that. Thank you.
Got it.
Member Danley.
I really don't see anything that I would change, and, no, I really don't. I think we're covering and securing and understanding, and it's a good visual aid of our zoning district, so I have no other comments, really.
Thank you. Member Miller.
My one concern was that. The other concern I have, the open space that's part of a Green Bay. What's the name of the subdivision? I'm drawing a blank. The homes, the big homes.
Tangley Oaks.
No, on the other side.
Belforet?
Harbor.
Belforet. You have an open lands back there, is that correct?
It's owned by the homeowners association, not the park district.
Oh, it's owned by them. Oh, okay.
Yeah, so that was another maybe quirky but consistent choice we made, was where you have these outlots that are owned by homeowners associations. So Belforet is one, the Swiss cheese, if you would, of Tangley Oaks. There's some similar situations down here. You know, where a homeowners association is responsible for that, we treated that as just really being accessory to the residential use.
And I have nothing to add then.
Thank you, Member Miller. Member Murray?
I think that the comments that have been made by my fellow members address most of the current points. I'd go back to emphasizing that what I'm most enthusiastic about in the ordinance that we're recommending that the village board adopt tonight is it's a framework for an open and transparent discussion of these issues as a community. I think that the comments that we've all received tonight, including those of Ms. Bjork and others, are all very much welcome. I think that Lake Bluffers feel passionately about our common lands. I think that no one wants to see a rush to decision-making on the disposition of any piece of land if it's going to be repurposed in terms of use. I think we've all looked repeatedly at the parcels under consideration, and I think that they're all being moved into Rio with all due consideration. So I don't have any specific changes to recommend to the rezoning as recommended, but I would just make sure that everyone who really takes the time to understand what we're doing tonight understands that what we're trying to do is set the ground for that kind of open and communal discussion about the use of our public lands going forward.
Yeah, well stated. That reinforcement, I think, is very beneficial. Member Russell?
No further comments.
Any further discussion with respect to the proposed rezoning of properties into the Rio zoning district? Hearing none, do we have a motion?
I'll make the motion to accept the map as stated in the document.
Thank you, Mr. Miller. Is there a second?
Second.
Vote, please.
Once again, the order is random. Member Burns.
Aye.
Member Danley.
Aye.
Member Badger.
Aye.
Member Murray.
Aye.
Member Russell.
Aye.
Member Miller.
Aye.
Chair Peters.
Aye.
Motion carries.
Thank you. As I understand it, then, both matters will be before the village board sometime when they meet in January, I take it.
That's correct. I believe the date will be, I've got January 14th.
All right, thank you.
Thank you for joining us.
All right, agenda item number 7, staff report.
Sure, so no substantive staff report except to direct your attention to our meeting dates. You don't need to take any action on these, but we publish them for you to see and make sure you're aware of, and then we will publish this on behalf of the Plan Commission and Zoning Board of Appeals shortly after the first of the year. Again, we're keeping our regular third Wednesday date through 2019 is our expectation. We didn't, I don't believe we saw any big hiccups there. As they come up, as you know, through this year, through 2018, we adjusted things as necessary for, I know, for Jewish holidays or for other events and observances, and as our schedule needs them. So always open to conversation there.
Any issue with respect to traditional spring break?
I think it's the 25th through the 29th, I imagine, but I'd have to confirm.
Yeah, I'd rather avoid that conflict if we could.
Yep, I mean, we'd have to confirm it. Haven't looked.
Good, thank you.
It is the 23rd. Yeah. Saturday, the 23rd through the 30th. Or so, the 25th, yes.
Okay.
We get the 25th.
Great, thank you very much. Commissioners report.
One question, speaking of the comp plan work getting a little stale, do we have a meeting planned for that, that is on my calendar that I'm not finding, or?
We do not have a meeting planned for that at this time, so the bulk of our staff work has been spent getting this thing packaged up for you.
Come on.
You know, believe it or not, typing out 4 pages of 200 parcels takes a little bit of time. I was kind of surprised by it. But that,
So, I mean, I'm not
We're
trying
gonna get it
I'm not
back
trying
on
to
the
pin you
agenda.
down, I'm just curious, is it, you think it's February or sometime in January that we'll revisit that?
we'll see how much progress we make on the staff side. I would be surprised if not by February.
Okay, great.
I'd hope
Just,
to have something
I
soon.
wanted to confirm more than anything that I wasn't missing a meeting.
You are not missing a meeting.
Okay, great.
Any previews for next month?
Sure, so for next month, let's talk about a couple other groups first and then this group. So next, in the next month or two, things to pay attention to, sustainability, our Sustainability Community Enhancement Group that has member Leslie Bishop, formerly of this group, they're getting close, we think, at the start of February to finalizing some recommendations about corridor and gateway beautification. So that impacts some of these public spaces here along 176. A lot of interest in buckthorn and landscape, and some really trying to add some continuity to some of these very visible parts of the village. So stay tuned for that. Potentially also, that group is getting very close to having a full sustainability plan. Some of those topics touch on some in the comprehensive plan. I think you'd be pleased to see that we're talking from the same playbook. So again, stay tuned for that. I also know that the Historic Preservation Group is hoping sometime early next year to have a real deep conversation about what historic preservation looks like in the village, and maybe regulatory changes or outreach changes or things that can be done to make that stronger. There's also a survey underway of the East Terrace, the West Terrace, the North Terrace, things that will yield interesting results probably around the middle of the year. As far as this group, January right now looks fairly quiet. We have probably a front porch variation that'll come to you. I haven't had a chance to look at it too deeply yet. It came on my desk today, but that will happen, a small variation from the looks of it. And then, as you recall, when we had our parking discussions back in October, there was a longer parking rewrite that we continued to January. Again, your choice if you want to take it up at that time or postpone it indefinitely, but at least it'll be on the January agenda for you to consider.
When we give a variance, is that good for a certain amount of time?
So you have to, I don't know what exactly the term would be, build it or prosecute it. It's good for a year.
1 year.
And then
That's
it can be revoked. But of course, after it's built and it's in place, it's.
But if it hasn't been built in a year, do they have to come back for reapproval?
You know, I'd have to look at the question a little bit to answer that for you. I think it would need to, generally speaking, usually you have to act to revoke it. It doesn't disappear, but.
Yeah, generally, we can design it any way we want. I mean, we have the authority to not put a time limit on it.
Is there anything in the books right now about that?
Well, typically, we usually state that the village has the right to revoke if they do not prosecute the work within a year. So it doesn't hang out there. But that,
Okay, but for instance, we did a property last year on the corner of Woodlands and Sheridan, a porch extension that was kind of contentious, and we approved it, but it hasn't been done, and it's way over a year. Can they start it in the spring without coming before this board? Just out of curiosity.
do you happen to remember the property by chance?
It's right there. Find the map.
Is it
Pretty
a
funny,
per year property?
It's right, it's Woodlands and, yeah, right there.
Yeah.
Yeah,
So is Woodland, or Woodlands?
Woodland.
Woodland, okay. If you give me 1 second, I'll see if I have on my system the ordinance, and I can check and see what it says.
So while you're thinking, anything going on with Stonebridge?
Nothing. All's quiet. Smedbo,
Yeah?
Silent Night, Holy Night, etc. Smedbo, they're very appreciative. I should mention in my report, the village board approved your text amendments at their last meeting. So height changed, parking changed. They're still working with potential tenants to see if they've got the other parts of their deal. They're hoping to have a decision made early next year. So we think probably next 60 days or so. Very exciting.
Yeah, I guess before we adjourn for the evening, I'd just like to commend the village staff, village council, the commissioners, the various agencies that were actively engaged in the whole Rio project, as well as our predecessor board members for all of the hard work and diligence in bringing Rio to fruition. It's been a rather long process. It's been a challenging process, but I think at the end of the day, we've got a very, very solid ordinance, so I think we ought to be proud of what we've been able to accomplish.
If it's too much trouble, it's
Yeah, I'm having trouble
don't worry about
finding,
it, it's
but
not
we can
important.
certainly
We can
look.
get back to you, certainly.
Yeah.
Not important, just a curiosity.
It's important. We
Table
put
until
due
next
date on it for a week.
And something to consider, though, as you take up variation, special uses, when somebody comes before you, if you think it's appropriate to recommend a condition, that it only be granted, right, but it's something to always think about, only good for a year or at whatever time period, or maybe you think that's not appropriate and you don't want to put a time limit on it. But you always have the freedom to recommend, whatever you see fit. And I will tell you, there's certain properties in which we know that it's not going to be built in a year, and we'll make sure that we build in some extra leeway into the ordinance so that doesn't happen. But again, you can always do it any way you'd like.
Is there any reason to put a time limit on it? If we approved it once, I mean, does it really matter if they come back in 2 years, or they do it in 2 years? Does it really make a difference to us?
Well, where it may matter, and it depends on obviously the property and the neighbors, and, it's a unique analysis, but, so for example, you might have a situation where you say you're doing a side yard variation or something, and, when you say, to present day, this makes complete sense, the neighbor has nothing built that close, but 4 years from now, you could have other properties change, and that variation might be a much more, obtrusive porch, or a much more, things may have changed. So there are times that you may want to say, no, we're okay with it now, but if, we want you to come back as conditions change, and we may need to reevaluate because it may have different impacts on the neighbors.
It's reasonable to come up with a time limit.
Yeah,
on that, so.
yeah, and sometimes you can say, no, we don't really care if it takes you 4 years to do it, that's fine. And so again, it's a property by property analysis of what you think is appropriate.
Is that something this body wants to deal with, address, have an ordinance, or does it not
I
matter?
thought there was a standard provision in the lead to our zoning code that talks about typically variations are only good for a year, isn't there?
Emil?
Yeah, because if you don't do it after a year, then you're fined,
I thought we had that,
particular
Glenn.
fine that's in place.
And this is the ordinance for you.
Okay.
Again, I think
Isn't there?
we're working on it as we speak, but I think there is something in there about that, but I think ordinarily it requires affirmative action to revoke it. It doesn't just expire like
So we-
eggs. Or certainly if there's an interest in seeing this
I
done.
tend to agree with Ben here, that maybe it should be addressed because of changes in the neighborhood. I think maybe a quick look-see would not hurt this group, or maybe the village staff can look at it and see if there's anything in there that's quite different from what it was originally approved, and then come back here. I don't have strong opinion, but I do think it should be evaluated by somebody at some point.
So I do not see in here, in the ordinance itself, in this particular ordinance, a condition. And in terms of your code, let me look there to see if there's a code provision.
Ben Schuster in his native habitat, everybody. This is his element.
It's a lot of pressure.
Yeah, there's a lot of work, you know, there's only 6 of us, 7 of us just watching you.
Yeah. Could just make up an answer right now.
Yeah.
Okay,
I
here
would
we go,
almost think
here we
like
go. Here's the provision. For variations, so this would not apply to special uses. This would not apply to the plan development approvals. Time period, this is in section 10-2-4F. Subject to an extension of time granted by the village administrator pursuant to subsection F2 of this section, or by the Board of Trustees by resolution duly adopted, no variation from the provisions of this title shall be valid for a period longer than 1 year unless a building permit is issued for the construction for which the variation is granted is actually begun within that period and is thereafter diligently pursued to completion, or B, a certificate of occupancy is issued and the use for which the variation is granted is commenced within that period. So the village board does have the authority to extend the time. So that would be number one. But even if it's in the code, the village board still would be able to, in its final approval ordinance, be able to adopt a provision that says this shall extend beyond the period. So that, because you're a home rule municipality, you would be able to do that. But again, when you're considering it, you know, that's something that you can always think about. And as well as if you think that this code provision should be changed to give people more time, that's, you know, or not. I mean, it's whatever.
I think if it's in there, at least there's some validity to it. I don't see any reason to add to that. I was curious, because somebody asked me, and I said I thought a year, but I wasn't quite sure.
Any further discussion? All right. Is there a motion to adjourn?
Absolutely.
So moved.
Second?
Third. Second.
Voice vote?
Aye.
All in favor?
Aye.
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 I'll bet.
Thanks so much, Member Murray.
Cut that off.